I'm a 68-year-old retired electrician, and after a lifetime of hard work, all I really wanted was peace and quiet on a small piece of property my late wife and bought nearly 30 years ago. The land isn't fancy, just the acres of Texas countryside with a narrow gravel path that leads from the road to my driveway. That gravel path is my easement, legally recorded, permanent, and older than the hut that eventually grew around my property. For decades, that little road caused no more problems. Everyone knew it was mine to use, maintain, and access whenever we wanted. But peace never lasts long when A&R gets ambitious. A few years ago, the neighborhood around me expanded. New houses, new families, and of course, a brand new board filled with people who believed a clipboard gave them more power than the U.S. Constitution. They weren't bad neighbors, just overconfident. Especially the new President Linda. She was the sort of person who talked like every rule came straight from the Supreme Court, even when she made it up 5 minutes earlier. The trouble started the day he drove home and he found orange construction flags planted all along my gravel easement. At first, he thought it was a utility company marking lines, but when he followed the flags down the path, he saw a freshly posted sign, "Future Community Walking Trail Construction Begins Soon." He stood there staring at it, wondering if this was a joke. A walking trail? Through my easement? The same easement that had been on county records since 1974. The next morning, he went to the office to clear up what he assumed was a misunderstanding. But Linda greeted me like he was a trespasser in my own neighborhood. "Oh yes," she sighed cheerfully. "We're rerouting your access road. The wants to create a community trail to connect the new cul-de-sac. The board unanimously voted on it." He was stunned. "You can't reroute an easement," he told her. "It's legally protected. You can't build on it, block it, or take it." She smiled like she was correcting a child. "Mr. Peterson, the governs this neighborhood now. Your easement is pre-HOA and therefore outdated." "Outdated? That's not how property law works." He tried explaining politely, but she waved me off. "Construction begins in 2 weeks. You'll receive access instructions once we finalize the new path." He left the office shaking my head. He wasn't angry, not yet, mostly disappointed. If he lived long enough to know that some people only respect rules when a judge repeats them loudly. So, he contacted a real estate attorney. When he showed him my property papers, he laughed softly and sighed, "They don't have a case, but they're about to make your life annoying." And he was right. During the next 2 weeks, he got letters from the threatening fines if he interfered with community development. They sent landscapers who tried clearing brush near my road until he told them to leave my property. One board member even claimed he was blocking community progress, all over an easement that didn't belong to them. Finally, the day before construction was supposed to start, my attorney filed for an emergency injunction. A court date was set within a week. Now, picture the scene. A small county courtroom, a judge who's seen everything, myself sitting quietly in the front row, and the A&R board that walked in like they were suing the Pentagon. Linda did most of the talking, explaining to the judge that the had the right to modernize outdated routes and repurpose shared lanes. The judge listened patiently, then he turned to me. "Mr. Peterson, do you have documentation of the easement?" He handed over a folder containing the original 1974 plat map, the recorded easement deed, and the unauthorized reaffirmation from the 90s. The judge flipped through the papers, adjusted his glasses, and decided something you will never forget. "Ma'am, this easement is older than your entire subdivision. You cannot touch it. You cannot move it. And you most certainly cannot convert it into a walking trail." Linda tried to argue badly something about community benefit, but the judge raised his hand and decided, "HOAs enforce rules. They do not rewrite property law." He ordered a permanent injunction on the spot. The HOA was barred from entering, altering, or claiming any part of my easement. They were also warned that further interference could result in heavy fines. As we walked out of the courtroom, a few of the board members avoided eye contact. Linda looked like she'd swallowed a lemon. My attorney smiled and he whispered, "That went better than he expected." And from that day forward, nobody so much as touched a pebble on my access road. A few months later, the completed the walking trail on their own land, not mine. And he must admit, it takes a small bit of joy every time he drive past the trailhead, knowing the judge gave them a legal schooling they won't forget. He didn't want to fight. I'm too old for that nonsense. But sometimes you have to stand firm, especially when someone decides your rights are inconvenient to their plans. Rights don't expire, and the easements don't disappear just because HOA wants a prettier map. If you enjoyed this story, please like, subscribe, and share. Your support helps keep these real-life horror stories coming, especially for viewers who know that sometimes the law is the only thing standing between you